And we'll get underway. So welcome everyone to Administrative Law. This is our first tutorial for this term. So I'm really pleased to have you all joining me for this unit. Admin law is one of the toughest subjects that you'll do in your time here at uni. There's no getting around that. But I also hope that it will be one of the most enjoyable units that you do. It really is a subject that rewards you for getting involved, getting into the details of the unit. And so, yeah, you definitely get out what you put in. And so I'm hoping that we can have a really great term together as we go through all the interesting nuances of administrative law. I'll start this evening with just a very brief overview of what we're aiming to do in these tutorials. And then we'll go through, we've got some weekly discussion questions and things like that to talk through. So these tutorials are going to be as practical as possible. And I'll really focus on, more than probably anything else, trying to prepare you for the assessments that you'll have to do in terms of the written assessment just before Christmas, and then your end of term take home assessment. So first and foremost, we're trying to prepare you to answer hypothetical questions. And along the way in doing that, I hope that you'll pick up a thing or two about administrative law. But the main focus is on some of the practical elements, working through how do we think about administrative law problems? How do we think about the principles and the key cases that we're talking about in this unit? And then how do we apply those to those hypothetical problems? So approaching the tutorials with that sort of frame of mind will, one, help you with your assessment, and two, will give you a bit more of a sort of a concrete way of thinking about administrative law, because it can be a little bit abstract otherwise. The other thing that's sort of worth mentioning about in terms of the tutorials is you'll have noticed hopefully on Moodle that we've got a set of weekly tutorial questions. I've had a couple of questions about those. There's no requirement for you to submit those anywhere. They're not accessible. They're just a series of hypothetical questions for the most part. This week is a little bit different because we don't have, I guess, any sort of doctrinal content to go through, but a few hypothetical problems to give you practice at dealing with administrative law scenarios. You don't have to submit those anywhere. They're not accessible. Instead, what I would really like you to have done is to have tried to prepare an answer, or at the very least have read through the questions and have a think about an answer before you come to the tutorials. We'll discuss them. And then afterwards, if you've still got questions about the hypothetical, or you've got maybe a part of your own answer that wasn't quite discussed as much as you would have liked, you're more than welcome to shoot me an email or to put a post up on the general discussion forum on Moodle, and we can talk about it in detail. But they're not accessible, and I thought that was worth mentioning just because I've had a couple of questions about that already. In terms of the structure of a tutorial, for the most part, what we'll do is at the beginning, I'll give a quick recap of sort of the key points of the week, key principles, key cases, things like that. I'll then throw it over to you guys, and there would be an opportunity to ask some sort of general questions about the content. And that's an opportunity to clarify anything, go through anything in a bit more detail if we think it's needed. Then we'll run through the weekly tutorial problems. You'll notice, or as you go through, you'll see that some weeks have got more questions or a bit more detail in the questions than others. So we won't necessarily get the time to go through all the questions every week. But it's good to have, I think, more content rather than not enough, so that when you go away and you do your exam preparation, you've already got a bank of practice questions as well ready to go. So we won't necessarily get through all the tutorial questions, but sometimes we will. So we'll do that, and then we'll sort of wrap up in the last 10, 15 minutes of a tutorial by really going through in a bit more detail and talking about how you could turn the answers to those tutorial problems, how you would structure that in the sort of the assessment forms. So how would you actually go through and take the analysis that we've talked about and put that into the sort of the structure or the formula that would be useful to you in constructing an answer. So that'll be the general sort of structure that we'll use for these tutorials. Before we get into today's tutorial, just a very few brief ground rules for the tutorials. And the most important one, really the only one that matters, is that I expect you to treat each other and each other's opinions with respect. It's really important that this is sort of a safe zone to talk about administrative law, to to make mistakes. We all do it, and they're a great learning opportunity. So I want you to feel like you can say answers, and even if they're wrong, it's a learning opportunity, and there'll be no judgment, certainly not from me, but I hope not from anyone else as well. In some weeks, we will also have the opportunity to discuss a few topics that I suppose stray a little bit into the political side of things. One of the things that's probably most interesting about administrative law is the way that it kind of blurs the line between law and politics. So especially in topics like that, I do expect you to treat each other's opinions with respect, and even if you don't agree, a healthy debate is always good, but it's important that you treat those topics and those opinions with respect. A sort of a sidebar to that is, of course, that these tutorials are recorded. And I suppose it's important to be aware that in participating in the tutorials, you're consenting to being recorded. The chat down the sidebar, I'm happy to be, I suppose, a bit more confidential, because I do understand that not everyone feels comfortable talking on the screen, talking on the camera. Counterbalance to that, I do believe in giving credit where credit's due. So for the most part, things that appear in the chat, if someone's had a really great idea, I'll credit them with that idea and I'll say their name in the chat. But if you would prefer not to be identified in the chat, just put a little confidential or anonymous or something before your answer, and I'll say the good thing about it, but I won't mention your name, and the chats won't be saved or recorded or posted anywhere. So I think that hopefully will strike a good balance between, making these tutorials open and accessible for people who can't attend at the time, but also creating a safe environment for people who don't necessarily feel comfortable being recorded or being on the Zoom screen and things like that. You'll have noticed that we've got weekly quiz questions, and the first one has opened up today. So if you haven't seen that, I do encourage you to have a look after this tutorial. There's just the one question for each week. So it's not designed to be an especially onerous piece of assessment, but it's just a good way of sort of ticking along throughout the semester, making sure that we're engaging, making sure that we're paying attention and keeping up to date with things. You get 2 attempts for the quiz. So my advice, and obviously you should do whatever works for you, but my advice would be to have a look on Monday morning, see if you can answer it, and to lock in an answer if you're feeling confident. But then after the Monday night tutorials, go back and have a look. And if you feel like you want to change your answer, there is that second attempt that gives you an opportunity to do that. Now, of course, the asterisks on that is that we're obviously not going to be giving away, or trying not to give away, answers to the tutorial questions. And so please make sure when we're engaging in these discussions that you're not giving away the answer to the tutorial questions. I think for the most part, we should be right. Certainly, I wouldn't think that you'd accidentally be giving it away, but just to make sure that no one comes in here and says, hey, everyone, the answer to this week's quiz is this. Please don't do that. I think that's everything that I've got to say in terms of ground rules. Are there any sort of other expectations or things that anyone else would like to make sure are sort of on the record or covered in terms of the way the sort of the rules of engagement for this course? I'll take that as a no. Well, and I suppose the last thing is please do make sure that you participate. It's a lonely hour if it's just me doing all the talking. This is your main opportunity to engage with the course, to engage with me, and to engage with each other. So please definitely do participate. And to, I suppose, encourage you to that end, I've got a couple of quick warm-up questions and activities that I'd like us to do. So the first two are just true or false. So what I'd like you to do is I'll ask the question and then just put a true or a false in the chat. And once I think, most people who wanted to answer have had a chance to answer, we'll have a quick discussion about it. So first question, true or false, administrative law focuses on the decisions of the executive government. Brilliant. Lots of trues. Correct. Fantastic. Nice, easy one to start. I think the next one's pretty easy too. True or false, administrative law is not concerned with public accountability. Lots of falses. Excellent. Nicely done. Nicely done, everyone. All righty. I'll share my screen. I've got a multiple choice for you. Which of the following sets of parties would you expect to find in an administrative law dispute? A, employer or employee, B, the Crown and the accused, C, the executive government and people or corporations, and D, a person and a corporation. Alrighty, lots of C's. Fantastic. A few people saying D. Does anyone who said D want to elaborate on why they thought that might be an answer? That's cool. I guess I would say why people have said D, just as I suppose a bit of a learning experience, is because on the one side of the scale, you'd have a person or a corporation, whereas really what's key with administrative law is an action involving the executive government. And so what these questions are presenting sort of the pairs in a dispute. You could certainly have a person and or a corporation on one side of a dispute in an administrative law setting, but to capture both sides of the dispute, you'd need the executive government as well, which is why the answer is C to that one. Last one. Oh, I shouldn't have. I'll stop sharing that. Last question, for those of you who didn't see it then. True or false, I'm looking forward to studying administrative law this term. True. Okay. False. That's fine. Look, I'm acutely aware of the reputation that administrative law has. A few of you who have said false, I hope I can change your mind throughout the term. It's not as bad as you've heard. It's hard, but not bad. So it's compulsory. It is compulsory, but that doesn't mean that we have to. We can still have fun with it, even though it's compulsory. Kim's asked what the reputation is. Well, I suppose we can take a brief detour. What have other people heard of about administrative law? I suppose, what are the expectations or the sort of the preconceived ideas that people have about administrative law? Hard, nervous about the level of difficulty, tricky, hard. People seem to find it hard. Not black and white, hard to answer. Yep. Yeah, it's a tough subject. There's no getting around that. But and I think I said dry. Yeah, it can be dry, but only if you don't embrace it, I think. Yeah, it's a hard subject. Hopefully you've seen, I think it was in either the first week's tutorial, the first week one lecture or the sort of course overview. It's a hard subject if you get bogged down in the details, but it's a subject that's much easier if you take a step back and think about sort of structurally, where are we going with all of this? And that's why I've provided a roadmap on Moodle for the course as a whole to sort of step through each part of the process. And I think that will really help lower the difficulty level, because it is easy. I'm not going to pretend that it's not hard, but the difficulty comes when you get lost in the details of, what's judicial review and what's merits review, and is this necessarily what's the purpose of this statute, all that sort of stuff. Those, when you get caught in the weeds, it can be tricky. But if you can take a step back and see conceptually, okay, where am I going with this? Why does this question kind of matter? When you can put it in that context, it is actually easier to answer that question. So it'll be hard, but hopefully not as hard as you've heard. And the important thing to remember as well is that I'm here with you guys right throughout the term. If you are struggling, and that's completely reasonable and understandable, please definitely do reach out. More than happy to have a chat and to help you through, because it's a tricky subject. Hopefully it won't be dry. Hopefully we can keep things interesting. And then, yeah, a few comments for people who enjoyed Constitutional. If you enjoyed Constitutional, you'll like admin law too, because they flow very nicely on from one another. If you didn't like Constitutional, you might still like admin law, so don't give up on it straight away. Excellent. Let's move on. Before we get into today's weekly questions, which are a little bit different from the kinds of questions we'll normally be asking, are there any questions about the course or about this week's content? Okay, I'll take that as a no. That's good. Hopefully that's good. So our first sort of question for this week is, what kinds of administrative decisions does the government make that affect your life? What sort of administrative decisions are having an impact on the way that you, live your day-to-day life? Taxes?
I'm in Victoria, so we've got lots.
Yes. Well, it really has been a good year for administrative law, in the sense of, really looking at what power does an executive government have over the lives of citizens, and really pushing what are the limits of executive power, and turns out they're pretty big under the right circumstances. Ability to obtain a license, for example, a driver's license. Centrelink, absolutely, definitely. Taxes, rego, child support, immigration, definitely. Parking permits, licenses for shooters, animals, payments for Centrelink, taxation schedules, stamp duty, definitely. The debt threshold for HEX, yes, I think so. Interest rates from the Reserve Bank, yep. Although that's a really interesting sort of, I suppose, line between public and private law, in that the way that the Reserve Bank acts as sort of a corporation and sort of a limb of the executive government, and then the way that the banks that we deal with then choose to deal with those interest rates as well, is a cool kind of combination of different things going on. Definitely the different decisions about COVID and the different restrictions and everything like that has been certainly administrative decisions that have had a huge impact on a lot of people, especially our friends and colleagues down in Victoria. Birth, deaths and marriages, yep. Working with children checks, absolutely. Immigration. So we've got a question from Kat. Does administrative law focus on Commonwealth or Queensland, state, or both? So administrative law, well, actually, I'll throw it over to everyone else. Does anyone else want to have a go at answering that question first? Both. Lots of answers for both. Does anyone want to elaborate on that answer?
I believe I read or heard you say that we're focusing on the Commonwealth because each state jurisdiction is slightly different in the way that it's structured.
Yeah, absolutely. So administrative law operates at both sort of federal and state levels. And that's because, the nature of our system of government is that we've got executive governments at both of those levels. So administrative law as a body of law operates at both levels. For this unit, we focus almost exclusively on the Commonwealth level because, as you said, Tammy, this is a course that goes out Australia-wide, and there are just too many little subtle differences between all the different jurisdictions. We'd be here all day talking about the things that Queensland does slightly different to the things that New South Wales does and things like that. So we focus on the Commonwealth, but most of the principles and ideas play out at the state level in pretty much the same way. Could be local as well. Yeah, local government's an interesting one as a sort of a creature of state law, but certainly local governments do exercise executive power as well, and local government decisions can be reviewed under administrative law too. So factoring in kind of local is an important addition as well. So thank you, Stephen and Kerry, pointing out local government. So as we've seen, there's a huge range of what the executive government can do. And there's a huge range of administrative decisions that can affect our day-to-day lives. And I hope that little exercise kind of, increases, I suppose, the awareness that, this is just something that affects a lot of people, and it affects a lot of people on a day-to-day basis. And so, it's an important unit of study just from the simple fact that, at any moment, any executive government can make a decision that affects you. And this course sort of aims to, I guess, give you the tools to hold your own if the decision doesn't go your way, if nothing else, even if you don't end up practicing in administrative law. A quick question from the chat about the hotel quarantine inquiry in Victoria. Is that administrative law? I'll open that up to the group first. Does anyone want to have a go at answering that? Do we think that the hotel quarantine inquiry that's going on in Victoria is administrative?
I know the hotel quarantine delegation, where it went from state government using police to then privatising and using the private security guards, was definitely part of administrative law. It was privatised and sent out as a private function of the executive government.
Yep. Anyone else wanted to weigh in?
Maybe if I can have a little bit of a go at it. I think the decision was made by Daniel Andrews of the Victorian government and their executive branch to open up an inquiry, and they appointed an ex-judge to head or chair the inquiry, but it's not necessarily a judicial inquiry because it's not held in any of the jurisdictions that normally does such a thing. So I think it's executive.
Yeah, good answer. So it's what's interesting about the inquiry is that it is contained within the executive government, as you've said. It's certainly looking at a decision of the executive government, so an administrative decision. What will be important is that the terms of reference of the inquiry will determine the recommendations that it can make. And what's most important is that you know, the findings and the recommendations that it makes, most likely, I haven't checked them specifically, but they probably won't themselves have much force behind them. But what will be important is that potentially the findings of that inquiry do open up the opportunity for citizens to review the decision and to look at, okay, this was a bad decision, or, there were elements of the decision that were not handled very well on the face of things. And so what impact did that have on an individual citizen, and what can they do about that decision moving forward? So yeah, you're absolutely right. We're thinking about an administrative decision in terms of deciding how to enforce the hotel quarantine, and therefore reviewing that decision does stay within the executive because of the way that the inquiry is constructed. But it's a little bit different from, I suppose, the typical examples that we'll be thinking about in this unit, because for the most part in this unit, we're thinking about individuals or corporations challenging or asking for a review of an administrative decision, rather than another body within the executive sort of having a look at a decision off its own bat, if that makes sense. Let's move on to the second question. Have you had any experience with the system of administrative law, particularly in dealing with the administrative agencies, either at Commonwealth or state level? Have you ever asked for a reconsideration or review of an administrative decision? We've got a yes in the chat. Did you want to elaborate? I know that in some ways this is a bit of a personal question, so there's no obligation to share more than anyone wants to, but at the same time, these personal experiences can be really illuminating for everyone else. So if you're comfortable sharing, please do feel free.
Yes, Jacob, I'm a union leader, and we quite often use freedom of information applications to attack in our area of expertise, which is aviation. And we often do that to CASA, and quite often CASA will reject the things that we're seeking. But about 10 years ago, we applied for information in relation to maintenance facilities overseas and how they were inspecting or reviewing the overseas maintenance facilities under FOI, and they refused to release the documents based on the various grounds that I'm sure we will cover. And we went to the Administrative Appeals Tribunal and were successful in getting the documents out of CASA, and quite an extensive case. They had to pay $200,000 of legal fees for us by the time we got to the end of it.
Fantastic. Well, thanks for sharing that. Yeah, that's we'll talk a lot more about freedom of information next week, and the ways in which citizens or unions or interested parties within the public can get information that the government holds, and also, the means by which the government can block those requests. And we do see increasingly a trend of governments restricting access to information. So yeah, thanks. It's a really good example. In the chat, we've got a couple of answers. Requesting heaps of investigation reviews at the Residential Tenancy Authority from complaints as an agent, and a review of grades in a diploma. The review of grades is an interesting one. And we'll have a look at a case in a couple of weeks' time that really draws out this sort of tricky distinction between whether universities, and I suppose TAFEs as well, are administrative bodies and whether grades are administrative decisions. So I suppose stay tuned for that one. But yeah, the sort of the process can be very similar, even if it's not necessarily an administrative decision. But the process is can be very similar. So that's a really interesting kind of. Sometimes they are administrative decisions and sometimes they're not, which is kind of cool. Renee has worked for local government for 20 years and has dealt with a fair bit with state departments, including a few decision reviews. Cool stuff. Danielle's dealt with QCAT. Chloe's done some RTIs in Queensland government. Fantastic. So some of us have got a little bit of experience in the administrative law field as well. That's always really fun. Belinda, I'm assuming that was challenging a decision, Department of Home Affairs decision regarding an employer-initiated sponsor scheme. Amy's a decision maker for FOI applications. Oh, excellent. You're going to have a lot of fun next week. So Belinda's thing's still ongoing. Okay, well, we shouldn't touch that one too much. Fantastic. Okay, well, we're looking forward to freedom of information next week. That's really cool. I thought that I would share a brief story, I suppose, of my own experience. Before becoming an academic, I worked in tax law, which I suppose it's a fairly specialized, but broadly falls under the umbrella of administrative law, as some of you have identified. And one client that I had sort of stands out in particular. He owned a seafood restaurant, and the tax office, I won't go into the details, but the tax office said that he'd been underreporting the income from his seafood restaurant, and had apparently racked up this massive tax debt. And he'd actually done the right thing, but you know, the funny thing about tax audits is once the audit is in place, and once the assessment has been made, then it stands until you prove otherwise. And so what followed was a very, very lengthy legal battle, and it cost this client literally everything. He lost his business, he lost his house, his marriage fell apart. It was horrific on every level, challenging this administrative decision that shouldn't have been made in the first place. And he was right all along, but it really, it took everything to get that right decision in the end. And the reason that particular client really stays with me is because I think it does really highlight the human element of administrative law. And I'm not here to say that the government's a bad guy and we should be challenging everything they do, but in any modern bureaucracy of any great size, there are inevitably people who will fall through the cracks and who will be missed, who will be treated unfairly. And so really what we're thinking about in administrative law is how can we help those people? How can we make sure that people get the right outcome and get, as close to delivering justice as we can? So that's a share from me. And that's the reason why I think that administrative law is such an important subject and can be such an interesting subject, is because once we get past all the complex principles and different cases and things like that, we are dealing with people, and quite often we are dealing with the little guy trying to get a fair outcome against a decision that hasn't been made perhaps in the best way that it could have. Demi has quite rightly asked if he was compensated for his losses. He did get a bit of compensation, but that in itself was a further complex fight. But by that point, you can't resave a marriage with an award of damages. You can't get back the family home, all that sort of thing. So he did get a bit of compensation, but not really. And that's the tricky thing about admin law sometimes. But that's hopefully, I guess, highlighted that this is a subject well worth studying. Well,
Jacob, sorry, can I just say a quick thing?
yeah, of course.
I haven't had an experience personally, but through work I've seen reasons for decisions come back from work cover who have rejected a workers' compensation
Yep.
claim. So and also having to apply for medical records through RTI and police reports and things like that. You have to go through the freedom of information and that sort of thing. So I've seen quite a bit of that. I just had a really quick question regarding the work cover side of things. When they make a decision on a claim, they usually give reasons for decision with the decision.
Yep.
So so nobody has asked them for the reasons for the decision. So is it just something that they do? It's not something that has to be applied for as such?
Yeah, so it's and this will be I guess the theme of the unit is the classic it depends. But it depends on how the primary legislation is worded. So in this case, the Work Cover Act. Some primary statutes specifically say that a decision has to be accompanied by the reasons for that decision. Some primary acts don't, and so the decision maker doesn't have to give the reasons unless you then apply for it. And so thinking about the way that this unit is structured, and so thinking about, next week we talk about reasons for decision and information, and then we use sort of the results of that step to then inform our merits review or judicial review. If the decision comes with the reasons already attached, then we can skip that step and go straight into a review of some sort, although we would still probably want to think about whether a freedom of information request would be appropriate or would yield anything, or if there was some problem with the reasons itself, if it didn't actually give detail on the actual reasons or something like that. We'll talk about the specifics in more detail next week, but if there was some flaw with the reasons, you could go back again and ask for better reasons. But yeah, to answer your question, sometimes a decision comes with the reasons, and then we don't have to worry about sort of that step that we'll be discussing next week.
Thank you.
That's all right. The third question for this week is a bit of a quicker one. In what ways can executive government decisions be reviewed? What are the avenues that are open to us? Tribunals? Yep, absolutely. The AAT as a specific example of a tribunal? Sure. Yeah, so broadly we're thinking about merits or judicial review. So judicial review obviously being through the court system, some sort of administrative tribunal usually being part of merits review, the ombudsman. Yep, yeah, absolutely. Sorry, I've cut you off there, Jay. Did you want to say a bit more?
I was just going to say the Ombudsman's office normally is the reviewing body. They do review into government decisions, but the different state and Commonwealth ombudsmans, depending on the jurisdiction.
Yeah, definitely. Absolutely. We don't get much of a chance to talk about ombudsman's offices in this unit, but certainly ombudsmen do play a key role in the departments or the policy domains in which they exist. And those are another form of merits review that's sometimes available to us. Internal review by government agencies as well is often a really important step. So for example, in taxation law, when you get an assessment that you dispute, the first step is to actually send it back to the ATO for an internal review. And then they'll have another look at it. If they still, if you still don't agree with the decision, then you can look at, your other options at judicial review, merits review, things like that. That's pretty much covered all of that. So that's a nice and quick one. Are there any questions about any of those kind of avenues? The main focus for this unit is judicial review, but also a bit of merits review that we'll talk about in week 3. But certainly judicial and merits reviews are the main avenues that we'll be talking about, but the ombudsman and sort of internal reviews are important elements of administrative law as well. Question 4, how would you distinguish administrative law from constitutional law? Very quick survey in the chat. Who has done administrative law already? Not yet, not yet, not yet. Last term.
Constitutional law?
Sorry, Caroline, I didn't quite catch that one.
Do you mean who's already done constitutional law or not?
Yes, sorry, did I not ask that in that way?
No.
So, okay, who's already studied constitutional law? Okay, some people have, some people haven't. That's cool. Some people did. Some of you did it last term, so everything should be nice and fresh for you. So this question goes out especially to you guys. How would you distinguish administrative law and constitutional law? Leanne says that constitutional law is in relation to the allocation of powers to the branches of government, and administrative law is to do with regulating the use of such powers. Yeah, that's a pretty good summary of the two. Marissa says constitutional law is the highest law. Yep, definitely. So constitutional law sort of framing the bedrock of our legal system. Administrative law, doesn't provide the rights and things like that in the same way that constitutional does. Chloe says that constitutional law deals in general with the power and structures of government. Admin law is limited to the exercise of power by the executive branch. Absolutely. So the key, in a really brief summary, constitutional law, we're typically thinking about the relationship between the legislature and the judiciary usually, but the key sort of question is, what can the legislature do? If you think about, the different heads of powers, what can the Commonwealth make laws with respect to? Defence, trade and commerce, all that kind of stuff. Administrative law is focused on the executive, and what can the executive do? What are they empowered to do by statute created by the legislature? Is a really sort of simple dispute summary between the two. Yeah, that's a really good summary. Constitutional law also deals with the validity of legislation. So when we think about a constitutional challenge, we're going at the legislation itself and saying this is not actually a valid law. In administrative law, we're challenging the decision. We're saying this is not a valid decision, but the legislation itself usually isn't in question. So yeah, that's a really good point as well. What might be the similarities between the two? Or are there any similarities between constitutional and administrative law?
I think there's a similarity where it relates to how the government interacts with the people and how the people's rights are measured in that environment. So I think that's probably a similarity.
Yeah, absolutely. So they're both within the sort of the public law domain. They're dealing with the relationship between the government and citizens. Yeah, absolutely. Both consider three arms of government and their different roles. Yeah, absolutely. So the separation of powers is a huge feature in both constitutional law and administrative law, but they play out in slightly different ways, which we'll look at in the next question. Stephen's claimed that they're both boring. I'll leave it to each of you to decide for yourselves whether you agree with that one or not. Let's move on then to sort of thinking a little bit about the separation of powers. Onto the fifth question. Have you ever heard of the Administrative Appeals Tribunal? I know from our previous discussion, some of you have. Is it part of the federal court system or the executive, and why would that distinction matter?
Executive.
Yep, so AET part of the executive. Why does that matter? Why does it matter that it's part of the executive and not part of the court system?
I think separation of powers is one thing, but they review only executive decisions, and whereas and then in their review process, they can also do a merits review.
Yep. Reading ahead, do you want to elaborate, or does someone else want to elaborate on what merits review is and why that's sort of important?
Okay, so the merits review has to do with the actual facts of the case and whether or not the decision was correct. However, I think in the case where it's a court, they can only review certain aspects. They don't rehash the whole thing. So they can only, I think it's something to do with just the decision making and the interpretation.
Yeah, absolutely. So it's, we're going to be talking about this distinction a lot over the coming weeks. So I won't, I suppose, dwell too much on it because, you'll be sick of it by the end. But very briefly, sort of the distinction, especially in relation to the AAT, what really matters is the sort of the outcome and the kinds of administrative decisions that can be looked at, but then also what we can get out of the review. So a judicial review, as Stephen has pointed out in the chat, can only determine points of law. A judicial review is focused really on the process by which a decision was made rather than the actual decision. And it means that when we go to think about remedies all the way in the distant future in week 11, if we're going down the judicial review path, all we can ask for is for the court to set the decision aside. Whereas under merits review, like with the AAT, we can actually ask for a different decision. And because we're dealing with the executive and rather than the judiciary, we can actually get a fresh decision, which is really what people are after when they're challenging the decision in the first place. Jessica has also pointed out that it's less expensive and more user-friendly and therefore more easily accessible to the public. Absolutely. So merits review in general tends to be cheaper and a bit less formal. The AAT is an interesting kind of a middle ground between the two, in the sense that it is a bit cheaper, it is a bit less formal, but it's still pretty expensive. It's still pretty formal. You go in and it's very much set up like a courtroom. And so the AAT is sort of an interesting kind of middle ground between the two there. And then, Yi has said as well that the AAT can make the decision afresh considering the facts. Absolutely. Speaking, I suppose, of facts, is the AAT bound by the rules of evidence that in the same way that a court would be? No, lots of no's. Excellent. Okay, that's good. So that's another sort of interesting distinction between the two, is because the AAT sits within the executive, it doesn't have to follow necessarily all the rules of evidence that bind a court. Often they choose to, just to give the process a bit more kind of impetus and I suppose a bit more kind of force behind its decisions. But they don't necessarily have to, and they can choose to accept evidence that might not be accepted in a court and things like that. And as Stephen's pointed out in the chat, there is also scope for the AAT to perform its own inquiries as they see fit. So if there's, a particular piece of evidence, a particular, you mostly see it in terms of expert reports. If the AAT thinks that there's going to be something that's really going to be relevant to their decision, they can actually go out and seek that information themselves rather than relying on one of the parties to submit it as evidence themselves, which does, potentially shift the way that the dispute plays out, and therefore sort of dispute the final outcome. Any other thoughts on the difference between the AAT being part of the executive and why that matters? One other thing that is worth mentioning as well about the AAT being within the executive, not only is it open to looking at the facts in a way that judicial review often can't, but it can also consider questions of policy in a way that judicial review usually can't. So, broader ideas of policy, principles of community fairness and things like that, those can also play into an AAT's decision and that review process, rather than in a judicial review you're only focused on the law, whereas the AAT can look at facts and policy as well if they need to. For those of you who have studied constitutional law recently, can you tell us a bit about Chapter 3 courts and why that would be sort of important here?
I think it's because they're set up as federal courts, whereas in each state, off the top of my head, can't refer to matters to the AAT previously, off the top of my head.
Yeah, so thinking about sort of jurisdiction is important. The key thing about Chapter 3, and that's sort of delving into the kind of the cross-vesting stuff, but what's, I suppose, more important from a principled perspective is the way that Chapter 3 courts exercise judicial power, and reinforcing, I suppose, the separation of powers discussion that we've had, this idea that if you're a Chapter 3 court, you exercise judicial power and you exercise nothing else. If you're a tribunal, you don't exercise judicial power, but you can do other things. And so really keeping that separation of powers, keeping those lines clean is important in thinking about the distinction between constitutional law and administrative law. But from the perspective of the AAT, really, I suppose, cementing its role within the executive rather than as a judicial body. Please do correct me. Is it pronounced Gory or Gowrie? Gory. Okay. So Gory's asked, isn't it more independent in its decision making? Compared to what? The AAT is interesting in that it is really set up to be an independent review body, and so it tries to function like a court in a lot of ways, and so the description quasi-judicial is kind of fitting. It does want to look like a court and seem like a court, and the independence of its decision making is a key sort of feature of that. But what we can't escape from is the fact that it sits within the executive, and we'll talk about this in a bit more detail in week 3, but it is worth mentioning now just to sort of steer us through the next couple of weeks. it is part of the executive. It's reliant on primary statutes allowing it or giving it the authority to review a decision, right? So in order for the AAT to be able to review a decision, a particular act like work cover or the tax acts, things like that, have to say a decision made under this act is allowed to be reviewed by the AAT. Whereas the opposite is true of judicial review. The presumption is that a court can review an administrative decision, and it's up to the act to specifically spell out, no, this decision can't be reviewed by a court. And even then, you know, the court isn't going to take too kindly to that most of the time. So yes, the AAT is set up to be about as independent as a tribunal can be, but it still is beholden to the executive in a way that the judiciary isn't. And so that, you know, that still has an effect on the things that it can do and the way that it goes about its business from time to time. The other thing, sort of thinking about the Chapter 3 courts, is that AAT members are not appointed for life, or they don't have tenure in the same way that a judge does. You know, there's not evidence of that being a systematic problem in terms of its independence, but it is another factor that, in thinking about the distinction between a Chapter 3 court, the judicial sort of bodies, and executive bodies like the AAT, you know, we want judges to ensure that they're independent, to have the security of tenure.
What's the process for enforcement of decisions? So a decision by the AAT or any type of administrative body, as opposed to that of a judicial body, they're different, right? And one of them is automatically enforcing, the other one you have to take an extra step to enforce it. Is that correct?
Yeah, absolutely. Yeah, definitely. So a order from a court under the judicial process is, sort of, you know, automatic and sort of self-creating. An order from the AAT or merits review, because it's still within the executive, what's sort of interesting and important is that it can then itself be reviewed via judicial review. But if you're happy with the decision and you want to enforce it, if you're having problems, so, you know, having problems getting the decision maker to follow the direction of the AAT, follow the decision, it is a further step to then take it to a court and have the court issue an order sort of confirming the decision of the AAT. So so absolutely, it can be an extra step. It's if the decision itself isn't disputed, it's usually not too painful a step, but, you know, there are still costs involved. There's still time involved. So yeah, there is that sort of little element of uncertainty that hangs over decisions of the AAT or other executive review bodies that don't apply to the judiciary. Absolutely. Any other final questions or comments or concerns for this week? Brilliant. Well, we might leave it there. Thanks very much, everyone, for coming along. We'll talk to you next week about access to information. So freedom of information and reasons for decision. So looking forward to seeing you all then, especially Amy, the FOI officer. This should be good fun. So we'll see you all next week. Thanks very much.
Thank you.